Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. In this video, we are going to speak about one of our recent success stories, an employment-based adjustment of status approved without interview. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. We recently had an employment-based adjustment of status approved without interview for the employee, the spouse, and child under the age of 21 and unmarried. In this case, the United States Citizenship and Immigration Services approved the employment-based adjustment of status for the principal applicant and the child without a request for further evidence. However, for the spouse, the United States Citizenship and Immigration Services issued a request for further evidence concerning Form I-693 medical examination because parts of that medical examination, which was completed by the USCIS approved civil surgeon, were missing. So what we did, we filed the response for the request for further evidence with a new medical exam enclosed, and thereafter the spouse's adjustment of status was also approved within days of USCIS receiving the response to the request for further evidence. The processing time for this employment-based adjustment of status case was 6 months, and that is because the case was filed under the EB1C visa category. Typically, the EB1C category is current and is a first preference for multinational managers and executives, and the adjustment of status was approved within 6 months. Also, with this application for adjustment of status, we did not file an application for a work permit and travel document, and that is because the principal applicant and family members were in the United States on a visa that allowed them to work in the United States, and therefore they didn't need that work permit or the travel document, because under their current status they were allowed to work and travel in and out of the United States. So those applications were not needed. However, in general, if you are filing for an employment-based adjustment of status and you would like to obtain a work permit or a travel document, then you can simultaneously with your adjustment of status application file the application for the work permit and the travel document. Or if you have not filed them simultaneously with the adjustment of status, you can always file the work permit and the travel document application after you have filed your adjustment of status. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.